Good afternoon, everybody. My name is Avery Bazell. I'm the community organizer here at CSS. I also coordinate our roundtables, and on behalf of our president and CEO, David Jones, we'd like to welcome you to the Community Service Society and welcome you to our Reentry Roundtable. This year was an exciting year in Albany with a new majority in the Senate. We saw progressive legislation passed before the budget, during the budget, and even after the budget, which we hope is a new normal for New York. As advocates and organizers, we found ourselves up in Albany a lot. And as a result, we've seen historic legislation get passed in various areas, from election reform, housing justice, driver's licenses for undocumented folks, and criminal justice reform. And that's why we gather here today, to discuss what happened when it came to criminal justice in Albany this year. What impact will that have on our family, our friends, our members, our clients, and our community? Did we get everything we wanted? No. But we did get some significant changes that is important to highlight. Also, where do we go from here? We know that although the legislative session ended a week ago, the work doesn't stop, and we will continue to work throughout the summer and fall to be ready for January 2020. We're excited for this dynamic panel that's here with us today. We have Tracie Gardner, who's the Vice President of Policy Advocacy at the Legal Action Center. At LAC, Tracie spearheads major initiatives and fosters strategic partnerships that support LAC's mission. From 2015 to 2017, Tracie served as the Assistant Secretary of Health for New York State, where she oversaw the state's addiction, mental health, and developmental disabilities agencies. Tracie has worked almost 30 years in the health and social services policy arena as a policy advocate, trainer, and lobbyist. Tracie received a BA from Mount Holyoke College. Let's give it up for Tracie. We also have Nick Malinowski, who's the Civil Rights Campaign Director at Vocal New York. Nick joined Vocal New York in April 2017 to work on their criminal justice and civil rights campaigns, which include ending broken windows policing, closing the jails on Rikers Island, and removing barriers for people on parole, among other issues. Prior to joining Vocal, Nick worked at Brooklyn Defender Services, where he focused on policy issues, client engagement, and community outreach. And last but certainly not least, we have Martin LaFalce, who's an attorney at the Legal Aid Society. Martin graduated from Georgetown Law School in 2008 and started working as a staff attorney at Rikers Island with Legal Aid's Parole Revocation Defense Unit. There, he represented clients who were charged with violating the terms of their parole and faced return to state prison. In 2012, he transferred to the criminal defense practice in Manhattan, where he has worked since. At both PRDU and the CDP, he has been involved in law reform efforts. Since 2015, Martin, along with his colleagues, have been working on challenging New York's gravity knife statute by supporting state and federal litigation that sought to strike the gravity knife statute as void for vagueness, and working closely with the legislature and the governor's office to repeal the gravity knife ban entirely. These are our panelists today. Let's give them a round of applause. And with that, we're going to ask them to come up. I'm going to hand it off to our general counsel here at CSS. She's also one of the co-chairs of the Coalition of Reentry Advocates, Judy Whiting, who will be our moderator this afternoon.
Good afternoon. Nice to see everybody here. We're going to seg right into our panel. I don't really have any introductions other than what Avery has already said. It's just interesting to me that some people list their years of graduation from law school. I stopped doing that a long time ago. Yeah. So you can kind of judge how that works out. But we're really, really pleased to have such expert people with us who have really been so deeply involved in, trying to make things right. And this is a year when we actually could make some things right. It's the first time in I would say recent memory that we had the stars align. The legislature was Democratic. There were people who were going up there to do a job, and they saw that they had a real responsibility, and they fulfilled it. Now, obviously, everything that we wanted to get done did not get done, and we're disappointed on a number of levels. But gosh, compared to last year, I mean, this is a light years different. So what I thought I would do is ask Tracie, who has to actually go lead a webinar after she's done with this, to start. She's going to talk a little bit about, mostly about what happened in the budget. There were a number of reentry-related matters in the state budget. That's normally the way things have happened in past years, before the legislature was fully democratic. If you wanted to get anything done at all, it was in the budget. And this year there is significant stuff in the budget, but wait, there's more, and we'll talk about that too. But perhaps you could start with the budget.
Okay.
And we're also probably going to be segging a little bit with Samantha Reiser, who is Legal Action Center's Skadden Fellow, who worked very heavily on a couple of other issues that we'll talk about.
Well, more than a couple. Okay, because I'm not a lawyer. I just boss them around. And Samantha and Kate Wagner-Goldstein at Legal Action Center, without them, we would not, at least for the center, our participation in the work that happened this session would have been zilch. We really are deeply appreciative of their brilliance. So I'm going to talk a little bit about some of the reentry items that were in the budget. And as Avery mentioned, I did time with Andrew Cuomo. And it's really important to understand that the advantage that the governor has in introducing legislation and in putting basically whatever he wants into the budget, because the legislature can only approve it or reject it, and they almost never reject it. So it is to the governor's advantage for his agenda to be able to get things in the budget. It also reduces the ability to have a lot of conversation or debate about issues, because again, it's either in the budget or it's not in the budget, and the legislature can really has no latitude to weigh in. So we have a new, brand spanking new Senate that is Democratic led. That's the first time in 30 or 40 years. And I say this because it's one of the reasons why marijuana legalization did not get done, is that the legislature was adamant, the Democratic Assembly, the Democratic Senate, headed by a black man for the first time and a black woman for the first time, wanted to be able to have a significant say in marijuana legalization. So they opted to not have it in the budget. And we'll talk a little bit about the kind of pros and cons of that. But what folks should know that was included in the governor's budget, in the executive budget, we're grateful to the governor for including these, but almost word for word, they are pieces of reentry legislation that we've been advocating for decades, through this room, through a whole bunch of other places. So, the advocate's credo in New York, if Andrew steals your idea, then you won. Don't get mad that you don't get any credit, because if he owns it, then it's going to happen. But, and he will really act like he invented it himself. So I'm going to just jump in, and Sam is going to help me if I flub. So one of the issues that came up was the cost of the OCA criminal history search. Everyone knows what OCA is?
What is it? Office of Court Administration. I can talk a tiny bit about this one.
Please.
And then you can talk about the more interesting ones. So anytime commercial background check companies, of which we think there's about 1,500 operating in this country, creating background checks for private employers, if they're worth their salt, and many of them are not, but if they're decent, they will get their records from the Office of Court Administration, and they have to pay for them. Just like if I wanted to order records on Samantha, I could do it too. Anybody who's willing to pay a fee can get official criminal records from the Office of Court Administration. And it used to be $65 a pop. Now they've jacked it up to $95. The idea being that the extra money will be used to fund some of these new initiatives, I think, as well as civil legal services. So we tried to get We've tried for years to get a fee waiver provision in there so that people who can't afford $65, now $95, wouldn't have to pay it. That is not in there. So there's no fee waiver. It's $95 a pop. That's the OCA records.
So, again, and the other issue about this as well is if it's in the executive budget during the budget season, which basically runs from January to March 30th, these are generally issues that have some kind of fiscal impact. Another reason why people were concerned that issues like marijuana legalization was not included in the budget because it clearly has a fiscal implication. Good to report that there was a removal of mandatory bars on certain licenses, and that becomes effective immediately. Some laws go into place immediately, some are 180 days. This is an issue that many of us in the reentry community have worked on in terms of the sheer number of licenses and the complications of the requirements if somebody has a criminal record to be able to even apply for and qualify for the license. So in general, it amended certain licensing statutes to state that the license may be denied based on criminal convictions consistent with Article 23A. And that is good because many of us in the room and historically have worked to establish Article 23A, which really protects people with criminal records in employment, and it is one of the first pieces of legislation in the country to provide that kind of protection. So some of the licenses include check cashers, community district education councils, citywide councils, bingo suppliers, notary publics, which is critical, suppliers of games of chance, so I guess gambling in general. Okay, for games of chance licenses, bingo licenses, and for lesser of premises to bingo licensees. If somebody
Bingo's a big deal.
Bingo's a big deal. Insure adjusters and for employment with insurance adjusters, real estate brokers and real estate salespeople, work activity employers through Department of Social Services, and driving school employees. So again, kind of maybe to the general public, a kind of random array of licenses to now be included, but those of us, we know that these are the kind of jobs that in fact can, people can grow from, but if you can't get into it in the first place, that's the problem. A big win was removal of the mandatory 6-month license suspension for non-driving drug offenses. And that is effective immediately. And this was both an upstate concern, because you can't do anything without driving, and also downstate in terms of just being able to apply for certain or qualify for certain positions. So that was a big win. And again, these are issues that reentry advocates have been primarily working with the Democratic Assembly to develop. In many cases, these were pieces of legislation that were passed in the Assembly and then basically died a quick death in the Republican Senate.
Can I add something on driver's
Please.
licenses? I think the New York City impact of it is that a lot of people, when they were convicted of crimes that had these automatic license suspensions, they had no idea. And so you would be in your car driving around normally, stopping at the light. Maybe you're missing a tail light. That gives them a reason to pull you over and ask you, for your license and registration. When they would run the license, they would see that your license was suspended. And you could be then charged with driving with a suspended license, which is a crime. Also, license suspensions to get it unsuspended cost money, a lot of money. Mm-hmm. So this is a significant win, I think, on that front.
Okay. Okay, now this is definitely for the lawyers. Cases with no disposition after 5 years not reported unless the DA says pending. Now, this won't be effective until, I guess, March 30th, 2020. It's 365 days after the act. You want to talk about this?
Yeah, sure. In our office and at Legal Action Center and other places, including Legal Aid, we help people get copies of their rap sheets, and we review them for mistakes. We have one of our stellar volunteers sitting there who's eating. I'm not going to point her out, but we rely on volunteers to help us with that work. And what we see is probably 30% of the rap sheets have mistakes. It goes up and down, 30 to 50. The biggest mistake we see are entries where it shows an arrest. You're fingerprinted for the arrest. The information is sent to Albany. That arrest information's there, but there's no follow-up information. And so you yourself probably know what happened with your case, but if a fingerprint-based background check is done, an employer will look at that and say, as they have to our clients, oh, but you didn't tell me about that open case from 1985. Well, obviously they're not open cases, but they're treated that way unless there is follow-up information. Like, part of our big business in our work at the Next Door Project was trying to supply that information so it would no longer look like an empty open case. Now we're not going to have to do that. This is a significant win.
Did the DAs not like this?
The DA, we wanted it to be, no disposition after 2 years. The DAs have sort of fought this in the past. They still have their little... they still have a carve-out. If the DA says the case is pending, then it won't be, sealed.
Okay. Next is automatic sealing of pre-1991 dismissals and violation convictions. This will be effective 180 days after the act became law. This is one of those that even I would, some of our paralegals would see these issues pre-1991, if you, let's think about it. This is not something, given that kind of time, that should still be hindering people's access. And so this is definitely work that CSS and Judy and Legal Action Center and Brooklyn and Bronx Defenders groups have worked on. So it's good to get this out of the way. Again, something the general public would not understand, but it's like, plugging holes in a leaky dam that was created by mass incarceration, which of course started with Rockefeller. Charges that did not lead to conviction will not be reported for civil criminal record searches. I think that's pretty self-explanatory, which is a good thing.
Can I say a
yes,
little bit
please,
about it?
please.
What we're understanding about this and what we were fighting for is that if you are arrested, as many people are, on about 10 different charges, they never really intend to prosecute you on those charges, but things get jacked up so that they have some leverage. I'm just editorializing. If you were to order a background check, or you were to order a disposition slip about what happened in the case, all of those charges would show up on it, even if you were only convicted of one, or if you were, or something that they added. So, guilty until proven innocent is kind of how that was working. And so no longer will those charges show up and really, hamper people, as they should not have, but they always did.
And what does this exclusion go to?
Applies to DCG. Okay. This applies to reports that are created by the New York State Division of Criminal Justice Services. It applies on certificates of disposition that you would go to court and get. And it also applies to records that the Office of Court Administration sends out or provides to those background check companies in exchange for payment.
And then this piece of exceptions for records provided to qualified agencies for federal or state law enforcement agencies, I think is probably worth mentioning. The clash between the federal and state restrictions or issues happen frequently. Amendments to human rights law. This is about the ACD. Why am I talking about this lawyer stuff?
I don't know. Do you want me to?
No, just do the ACD thing. I'm going to talk about the mugshots.
Okay, sure. If you're charged with a crime and you go to court, either on a desk appearance ticket or, put through the system and arraigned in court, one thing that may happen in your case is that you're offered an adjournment and contemplation of dismissal instead of a criminal conviction. It's also known as an ACD. An ACD is not a criminal conviction. It means that the case is held open for 6 months or a year if the charge was marijuana, and that's a little bit shifty with the new decriminalization. But what would happen, though, is that we as public defenders, me as a public defender a long time ago, used to be able to say to our clients, this is not a criminal conviction. If anyone asks, you can tell them you don't have a criminal record. That's all cool, but if somebody ordered a rap sheet or somebody ordered information from the Office of Court Administration, that would still show up as an open case for that 6-month period or a year. And so what this is saying is that may still be happening, but employers are not allowed to consider an ACD as something that is detrimental to somebody. So
you can check the box and say,
I do not have. Yeah, you could always do that, but then employers would see this thing and they'd say, what, it's an open case. They are not allowed to consider this thing as an open case that could be in any way detrimental to you. So That's how this changed.
Right. This was, I guess, as I understood it as well, this took away the risk that you would be basically lying when you checked that you did not.
Yeah,
okay.
yeah. Mm-hmm.
Quick add.
Sure.
Tracie, part of what you're talking about is another.
You got to stand up.
Another.
Yeah, how about that?
So another amendment that was made as part of this law that Tracie is talking about is that it gives people the right to answer no if certain covered entities in New York State unlawfully ask about sealed convictions. So previously, if you had a conviction sealed, but an employer unlawfully asked whether you'd ever been convicted of anything, it did not specify any conviction that has not been sealed, people would be put in a tricky position because the employer shouldn't be asking that, but if they answer no, it's technically unlawful because there was no right to answer no. And this now gives individuals the right to answer no if they're asked that. So that's pretty big too.
Yeah, that's big. I mean, it actually says, and we will quote, an individual required or requested to provide information in violation of this subdivision may respond as if the arrest, criminal accusation, or disposition of such arrest or criminal accusation did not occur.
Right.
Translated, that means you can say no. So that's really big.
That's big, right?
That's a big thing.
Yeah.
Yeah.
And of course, because it's big, it's all quiet.
Right.
It's going to be on us to get the word out.
Right.
This next win, maximum sentence for Class A misdemeanor reduced to 364 days, is work done with our colleagues in immigration. And this reduces the 1 year. How does it happen?
Sentence.
Right. That would allow for someone to be deported. So it just a little bit of, just if I'm not a lawyer. It reduces the sentence for the misdemeanor to less than a year. If it's a year or more, then you can be eligible for deportation. Right.
So this doesn't make everybody perfectly fail-safe for immigration purposes, but this takes away a big loophole that ICE and others were capitalizing on. Yes.
So if I'm getting it right, if you get a misdemeanor and you have less than a year's sentence, you won't get deported. Can you hear the question?
The question was, she wondered if you got a misdemeanor and the sentence was less than a year, you won't get deported.
If that was the only reason, right?
It's not even that, unfortunately. I think it's very complicated. I think I can't say the answer is yes to that.
Because it has to depend on the misdemeanor of what kind.
Right.
Nick has some.
It doesn't have to do with the sentence. It's just what the crime is.
Right.
So my understanding is that under federal law, what makes you eligible for deportation is that you've been convicted of something for which the maximum penalty is a year or more. Right. So even if you were sentenced to 5 days, the maximum penalty of that charge is a year. And so you would be eligible for deportation. Under the new law, because it's 364, you're no longer in that category of it being the maximum penalty being a year or more. The maximum penalty is 364 days, so it's below that threshold.
So you can't get this deported.
I wouldn't say that you cannot get deported because the federal government wants to get rid of you, they'll get rid of you. But the idea is that under that specific rule that the federal government had, this takes away one piece of it.
Right.
It's like somebody's not telling the whole truth.
That's true. It's not us.
And then I guess we're going to go to your favorite issue?
Yeah,
Our
yours
favorite
too.
issue? Yeah.
Well, one of yours.
One of my many favorite.
Right.
Disclosure of mugshots are now prohibited under FOIL unless it will serve a specific law enforcement purpose. This is effective immediately, and it amends the public officers law to add mugshots to the items listed as an unwarranted invasion of personal privacy unless it serves a specific law enforcement purpose and disclosure and is not precluded by any state or federal law. So there was drama around this, of course, lawyer drama, so you can speak to it. But I think it... No. I mean, I think that this was about... it was initially a broader restriction, and it included mugshot and criminal information. But at the last minute in the budget process, this was deleted. NYCLU wanted to be able to have more information in order to get people off, in order to protect people, to have more information. And then I guess at the last minute, probably by somebody in the executive, that part was deleted. Sam, do you want to illustrate that?
I mean, I think
You're going to be up here anyway.
So I think initially, as Tracie said, this went beyond just mugshot photos, and it included criminal record information, and there was some concern around advocates.
Booking
information. And there was some concern from advocates that having booking information would make it harder to learn information about police officers and also public officials who broke the law. And so there was this big push to get booking information removed. And there was also just a lot of confusion about how this would work in practice. And at the last minute, booking information was taken out of the budget. So it's just mugshot photos at this point. Thank you.
Say it again.
Just mugshots.
Bye.
The real import of this is that in a lot of other states, I mean, I've been to Richmond, Virginia to visit my sister. I go to the Kroger supermarket, and I can buy for $0.25 a publication called Busted Mugshots.
Yeah.
And it is just a newspaper full of mugshots. People, it's entertainment, you know. I spent that $0.25. Lots of other people do too, or they wouldn't have a business. So not only do they print them, but it's online. There are lots of these mugshot companies online. And what they have tried to do in the past is get New York City and New York State, by filing Freedom of Information Law requests, to turn over all of the mugshots of everybody who is arrested in New York State. They tried that specifically in New York City. They submitted a Freedom of Information Law request to get information about people who were on Rikers Island, and they wanted pictures, they wanted arrest information, and they specifically said, even people whose cases end up getting dismissed, we still want that stuff. And thankfully, this case ended up in front of a judge who said, no, I'm not doing that. And that was affirmed on appeal, but it didn't have, she kind of went out on a limb. It wasn't entirely clear that the law would have supported that. So now that can't happen specifically. So that's a good thing. What we were hoping is that this would be a little bit broader so that when somebody's arrested, their picture wouldn't end up in the Post. Mm-hmm. This doesn't quite go that far. Mm-hmm. I don't know if you have anything to add while we're going along. Okay, good. Okay, he works for legal aid, so.
Yes. Just in the budget. Yeah. The question was there, because we're going to talk about we're talking about the legislative activities that happened during the budget session, and then after March 30th, a whole bunch of other things started happening. Mugshots did not come back up post-budget passage. People would try to fix it. I mean, again, even though it's included in the budget is basically a big piece of legislation. So that doesn't mean that in post-budget legislative session, you can't introduce legislation to amend it. But that didn't happen. So it's law. Mm-hmm. It's law. But law can be amended. Yeah. I think if anybody else has questions, you should save it for this one. We're going to switch out so I can head off to a webinar, which I just want to do a shameless plug for. We're doing a webinar on the state's application to the federal government to be able to allow Medicaid to cover services either 30 days prior to release or within 10 days of going to jail. Jail. Third in New York for, a year or more, it's state docs. And in that case, you actually know when the release date is. In jail, it's a little bit more difficult. So we are asking the federal government's permission, particularly in light of the overdose epidemic, to allow Medicaid to pay for medication, including medication-assisted therapies, psych, mental health drugs, case management, and consultations that, as you well know, don't happen for folks. So 30 days prior to release for the state system and within 10 days of admission for jails. If the federal government gives New York State that permission, it's going to address that gap that generally happens for people where they come out and all their Medicaid will only cover emergency room. It's going to do quite a bit to facilitate people to get leaving a correctional system and going to the next thing, a warm handoff. The rate of deaths, not just over overdose, is something like 12 times higher post-release. Yes?
I thought Medicaid could apply for it prior to release anyway, by the time you get out.
You can apply while you're inside, yes, but it doesn't mean that will be on when you step out.
Well, because I do remember when I was with Fortune Society and the men were coming from upstate going to downstate over at Queensboro,
mm-hmm,
they was there between 30 to 40, maybe 60 days.
Right.
So we would apply for their Medicaid, and by the time they got out, the Medicaid would be at the address they gave.
Right. So that
45 to 60 days before Medicaid. And if you know Medicaid, even though it's not actively active, and you go to the doctor or wherever, you can say it's pending, and they will retroactive that pay.
So we were hearing more, exactly, that it was sometimes. And it especially been the case with the treatment providers who are not part of the health department, which controls Medicaid, but more like, these are OASIS or OMH licensed programs. So in that sense, there was a very real gap. It shouldn't be 30, 40, it should be on, fully operational when people come out. Before, when you had to apply for them, like when they were in Queensboro, that made sense. Now, almost all health insurance, Medicaid and commercial, is part of the health exchange. And that people should not have that gap of coverage. So before they even come out in the state system, their Medicaid is already on. Yes.
Yes, and I don't know if this is going to be discussed at that meeting, but another barrier when individuals who are in the upstate prisons did apply and receive Medicaid, when some of them were released, it came up as saying that it was only for docs, so it wasn't matriculated over to where they could access it and actually use it.
Exactly. That's the issue where I don't want to get lost in the sauce, but technically Medicaid can pay for your care if you are in docs if you are out in the community, at the community hospital more than 24 hours. So that is also what will get addressed, is that the Medicaid will be full, with the full complement of coverage that you need for being in the community.
As soon as you release.
Before, 30 days before. Right, that'll be on.
Maybe one more question.
Yep.
I should go.
Sorry, so quick question, because my program actually provides Medicaid services on Rikers.
Uh-huh.
So we work with the sentenced men. So my question is, we're working on the health exchange. They're flipping the switch, my staff are flipping the switch to get outpatient Medicaid when they're released. Does this mean that they're going to flip the switch sooner than that, prior to release?
I think sentence is not considered, right? There's a restriction to using Medicaid while people are incarcerated, but I think sentence are able to be covered. So again, this is going to make full Medicaid available. So not inpatient or outpatient, but full. So folks from the outpatient program can start working with you before that person leaves Rikers. So it's a webinar. It's going to be archived, it's going to be taped, and we will get the word out to folks about how you can view it at your leisure. Okay? Thank you.
Thank you.
When you expecting the feds to agree with that?
Girl. Whose feds is this? Whose feds is this? She's asking me, when do I think the feds are going to agree with it? Other than the fact that, but this president said that the overdose opioid crisis is a state of emergency, so that allows things to move quickly. Thanks.
Thank you, Tracie. So I think before we go into the other things that were in the budget that had to do with marijuana, et cetera, I think I'm going to turn it over to Nick to talk about bail, if you wouldn't mind.
Sure.
Okay, just to mix it up a bit. Turn on your thing. Sorry.
Thank you. So also at the same time, all of that work was going on in the budget that Tracie was talking about. Bail reform also was navigated in that same process, which allowed the governor to exert a lot of pressure on the legislature and for them to come to a negotiation about how they wanted bail reform to look. What this meant for us who were advocating was it was like literally 1 o'clock in the morning, they are cutting stuff out of the bill and doing stuff in a room that you have no access to. And every once in a while, you get a text message from a legislator saying, is this okay? Is this okay? Should we do this? Should we do that? But you're not actually seeing anything that's written down until it's done. And then it's done, and it's done. And so what happened with bail is basically for most misdemeanors and nonviolent felonies, there will not be money bail anymore. And in fact, those folks will be prohibited from being put in jail pre-trial. So until your case is done and you are sentenced, you will not be going to jail if your charges are misdemeanor or nonviolent felony, for the most case. There's some particular charges, like domestic violence cases, where they can actually remand you if it is even just a misdemeanor, and that still is there. If you are accused of a violent felony, the system that we have now is the same. The prosecutor can ask for money bail, judge can set money bail. The one difference is that they used to only have to ask for 2 forms of bail, so they would typically use cash bail or a commercial bail bond were the 2 choices that you were given of how to pay your bail, and they will now have to also offer a 3rd form of bail that is it's like a court bond. So it's a partially secured or unsecured bond with the court. So instead of going to a commercial bail bond, you can actually just go to the court. With a partially secured bond, you would put up to 10%, could be 1%. You put up a little cash with the court. If you don't come back, you owe the whole bond to the court. With an unsecured bond, you don't put anything up front. So, you go to your arraignment, you get accused, the DA says, hey, we want to ask for money bail. And they will say, you don't put anything up front, you can go home. If you don't come back to court, you owe us, $5,000, $10,000, whatever they're going to do. So the hope is that at arraignment, this allows for more people to be released. Very hard to predict what will happen, right? Even though the intention is for more people to be released, I think history shows that we don't always get that when we're talking about judges, prosecutors. Yes.
This is for the state, right?
So this is for the whole state of New York.
The city got to follow it, right?
The city has to follow it, yeah. And so I think, Avery had mentioned before, the what's next piece of it. This is where it's very complicated. So the bail statute is state law, but then every county in the state has a unique criminal justice system, right? Different judges, different DAs, different practices. You have courts upstate where people do not have a defense attorney at arraignment, where there is not a court reporter, where things are not on the record.
The judge is a lawyer.
Judges are not lawyers, right? So every county will be required to implement this, but there will definitely be challenges to that. So basically, that's what the bail does, though. Is it, I think in the country, right, is the first time that there's actually a huge number of people that will be prohibited from going to jail before they are convicted of a crime. And so that's a very important narrative win. The what's next piece of the conversation is crucial. There are huge opportunities that come with this and huge risks. So we now have the way that the system in New York has been set up is jails have become a place where all kinds of social issues sort of at the end of the road, folks end up in jail. And so people are getting drug treatment in jail. They're getting mental health service in jail. They're getting health care in jail, where these things are not necessarily available in the community. So there are counties in New York State where we've seen over time money being cut out of community health care, being cut out of community mental health care, and all those services being provided in the jail. Now, all of a sudden, anybody who is accused of a drug crime will not be in jail, right? But pre-trial until they are sentenced. And so for some folks who might say the jail is the place where people got drug treatment, what are we going to do in the community? How are we going to so this bill will be implemented January 1st. So we have 6 months, right, to figure out how we're going to provide these services in the community. Even though this was done in the budget, there was no money attached to it. So the governor did not put anything in the budget to say, hey, in Broome County, we're going to need to put in $40 million to do community mental health. They did nothing. And so that's going to be a real challenge. In New York City, we're kind of better positioned than a lot of other places just because there are a lot of reentry advocates. There's a lot of services that are available. In many other counties, there is nothing. And so one of the risks that comes with this reform is that people will be continuing to suffer, right? People whose needs, however inappropriately were being met by going to jail, won't necessarily have access to those things in the community, and that will be a problem. Along with that is a risk of a backlash. So we've already seen since April 1st, news articles, DAs coming out saying this person is going to be back on the street come January 1st, right? This person is going to be your neighbor come January 1st, thanks to this horrible bail law, right? The reality is that if you had money, no matter what you were accused of, you were back on the street prior to April anyway. But what we've seen is a backlash beginning, and that if we do not meet people's needs, that backlash will be strengthened, and we'll be in a situation where community is going to be advocating for more people to go to jail. And we have seen, at least from the government, that they don't particularly care about that. And so it really is incumbent on us to do that work to make sure that in a way that this legislation is protected, right? The big risk of this legislation failing, and it's a threat nationally, right? We as a community nationally are trying to get people out of jail, help people have their needs met in the community. If we don't do this well in New York, it will set a very bad precedent for other places around the country that are trying to do this. The other big risk is that this ends up with a huge expansion of the system. So in some ways, one way to deal with community mental health is to put money into community mental health resources. Another way is to give it to probation. And, make it so that people have to get arrested to get access to these services. Instead, so now they don't go to jail necessarily to get services, but you have to get arrested to get access to these services. And so that's something that we are at least trying to keep an eye on, is how this stuff happens. Again, the governor did not set up anything. In the law, it requires every county to have pretrial services. There's no real rules for what those pretrial services look like. We've heard some counties want probation to do it. Some counties want the police to do it. Those would both be very bad options, I think, in my mind, right? Like, we want community people to be helping people in the community. But that's the infrastructure that already exists, right? Every county already has probation. Every county has a police force. It's very easy to say, okay, we are going to give millions of dollars to probation to now supervise people in the community that previously would have been in jail, or even previously would have just been released on their own, right? Like, there are, in New York City, about 70% of people currently get arraigned, go home, released on their own recognizance. Some counties upstate, that's like 30%, 20%. Many more people are going to jail. But one thing that we might see is a big expansion of onerous pretrial conditions that, again, could keep people in the system if they violate them. So we don't want to see people, with a curfew, you break the curfew, you're back in. You have to check in once a week. You don't do that, you're back in. We had a meeting with the Nassau County DA, and they were looking at the bail bonds companies. So the commercial bail bonds companies, again, hopefully this new bill will take away some of their market share. It's not a given, but the question is, what do you do? And so you have a commercial entity that allegedly supervises people. Is this something that counties can lean on to say, hey, we're going to contract with the bail bond companies to start doing pretrial services and pretrial supervision? So we do not want to see that either.
And they can just jump the charges to felony instead of a misdemeanor.
Exactly. So because we have a charge-based carve-outs in the way that bail reform was written, they very easily could say something that was a misdemeanor assault, now we're going to call it a felony assault, have the money bail, put you in jail.
So if you don't go to jail, you still got to get arrested to go to court?
So you would get arrested to go to court. There is one piece of the bail legislation that does deal with arrests, which is, I think, confusing and still being discussed what it actually means, because there's a language problem. But there's a list of charges forever that have been eligible for desk appearance tickets instead of what we call online arraignment. So you get, an online arraignment, you get arrested, you go to the precinct, you get fingerprinted, you go to central bookings, you go to your arraignment court 24 hours later. A desk appearance ticket, you get arrested, you get fingerprinted, you get released from the precinct, and you have a court date. So the law requires many more charges to be in that desk appearance ticket eligible category. So for most misdemeanors, you really should never be going through the process of central bookings anymore. The problem is that NYPD defines desk appearance tickets in a way that the rest of the state does not. So the rest of the state uses the term desk appearance ticket to mean a summons. And so the folks who are writing the law, and what the governor said was that the intention was pretty much any misdemeanor, you get a summons. So you don't actually go to the precinct. You get stopped by the police officer. They run your name. They figure out you have any warrants or anything like that. They give you a pink piece of paper and you go home.
And they don't print you.
They don't print you. What the city is trying to say is like, oh no, desk appearance ticket means you go to the precinct, you get fingerprinted, you do this, you do that. And so that, I think folks in the room may know better than me, but my understanding is that there's still a debate about what that actually means, because the intention of the law was for people to be getting summonses, but it doesn't necessarily seem that that's going to be what the outcome is. So that's the one piece, that's the arrests.
Derek, from the Bail Fund. Nick, you and I work very intimately together. With the passing of this new law, obviously it changes the way we do business. We're even considering closing our doors. We understand also that there's been some amendment to the Charitable Bail Act, which will also determine if we keep our doors open or the way that we do business. How does that charitable bail statute affect bail funds, not only in New York, but around the country? Well, particularly in New York.
Do you have an opinion on that? For real, do you?
Yeah, well, the situation is that currently we only could provide bail funding in the amount of $2,000 for low-level offenses. By stretching the 2,000 mark up to 10,000 allows us now to engage in providing bail funding for folks with felonies. But it also changes the discussion because for low-level defenders, we're talking turnstile jumping, arguments. But with the felony conversation and providing bail funding for folks with their bail up to 10,000, it changed the discussion not only for us, but for funders, for law, for legislation, and the way that we do business.
Yeah.
So on one side, it is a good intervention. On the other side, it causes some concerns and raises a lot of red flags.
Yeah. So just to clarify, and that passed like last week or something, right? Like, so at the end of the session, the legislature changed the charitable bail law. So the charitable bail law is what allows nonprofits to create a bail fund, receive donations, and then bail people out of jail, like Derek was saying, misdemeanors with bail under $2,000 or less. The new law, correct me if I'm wrong, says that you can now pay for felonies as well as misdemeanors and any bail up to $10,000. This law was not something that was necessarily advocated for by advocates that were working on bail reform. It was something that so we were asking at the beginning in January and for years before to get rid of money bail, period, for all crimes, right? There's no reason why money should have anything to do with the criminal justice system, right? It doesn't make sense that you have money, you get treated differently. If you don't have money, it really is nonsensical. There's all the evidence shows that money doesn't actually even bring people back to court to begin with, right? It's not nonsensical, right? It was established in a way to make sure that rich people did not go to jail. And that's the way that the system was set up, and that's how it is. And so we gave the legislature and the governor a lot of heat because basically what they were saying was we're going to keep money bail for serious charges. So if you are wealthy and accused of a serious charge, we'll make sure that you don't go to Rikers Island. If you are not wealthy, we can put you on Rikers Island. And so the legislature actually pushed this expansion of the Charitable Bail Act to say, well, we want to make sure that people who are accused of a violent felony and have a low bail, that there is some way of getting them out. Because, I believe, right, like the legislature is very sensitive to hearing these stories about, people literally dying in jail, right? And Cuomo, the legislature, do not want us saying, hey, this person died just because they didn't have a certain amount of money. So they raised the cap on the charitable bail funds to allow organizations like the Brooklyn Community Bail Fund to pay the bail. The challenge that Derek is describing is that this now puts the bail funds in a situation where they're no longer, bailing people out for turnstile jumping, marijuana, this kind of thing, but for serious felonies. And the onus now to put onto a nonprofit of dealing of plugging a hole that really the legislature should have dealt with is, to me, what is like the most unfair thing, right? Is that if the legislature wanted these people to be out of jail, they very easily could have said, we're not going to put them in jail. Instead, what they did is saying, we're going to allow nonprofits to take on the responsibility. Something bad happens, it's the nonprofit's fault. Something good happens, we don't really care, right? And so that, to me, it's like a very... it's like really disingenuous of the legislature and the governor to add this when they really could have just, in the bail reform, taken those charges out. I think to Derek's question about how it changes the landscape nationally is that, New York is in a specific position in the country about, right? Like, so people all around the country are talking about ending money bail, talking about Khalif Browder, talking about all of these kind of problems. And ending money bail, so again, to the county-specific question, every county has a specific criminal justice system. Every state has a specific set of laws that govern that. And so it is very challenging nationally to build a movement around criminal justice because it just happens so differently in all these places. Ending money bail is one thing that sort of everybody can kind of get with, right? There are some places that don't have money bail. There are some places that don't have cash bail. But for the most part, most jurisdictions in the United States use a system of money bail to sort who goes into jail and who doesn't. So a lot of people around the country are saying, hey, let's end money bail. And with the expansion of the charitable bail law, what they're saying is like, let's not end money bail, but let's allow kind of like nonprofits to become part of the system that is sorting people of who goes to jail and who doesn't go to jail. So instead of having, the judges and the DAs deciding, we're going to kick it to Derek. He's going to decide, should I bail this person out or not? And so I think the fear is that it, again, just how the implementation become an expansion, probation, parole, that kind of thing, that all of a sudden the bail fund, and we've even seen in New York City where now all of a sudden the city council has a bail fund, right? And these are the folks who pay for the cops, pay for the public defenders, pay for the prosecutors, and then pay for a nonprofit to get people out of jail. Right? Like it doesn't make any sense. It doesn't make any sense.
And it's going to be very difficult to get that money because they'll probably put it in the participatory budget, so we got to vote on how we want to spend it.
Who knows?
It's going to be a process that's going to be ridiculous.
Who knows? But I think the bigger question is like, what is the role of bail funds in terms of like, is this a project to demonstrate how the current system is not working, or does it become just another arm of the government to establish who should be in jail and who shouldn't?
Can you speak to domestic violence, like say incest or rape or something like that, in terms of felony bails or not bails or release, or how does that matter?
So it's really just the charge. So if it's considered a violent felony charge, except for certain robbery charges and certain burglary charges, you'll have money bail. The domestic violence thing that I mentioned earlier is for misdemeanor domestic violence. So it's for, a misdemeanor domestic violence case, and then say you get a stay away order that says you can't go to that person's house. You show up at that person's house, even though that's not considered a violent felony, they can put you in jail because it's it's a specific statute that's for domestic violence. Contempt, yeah.
We already talked about this increase about nonprofits that give $10,000. Does this have implications or negative effects on this sort of like risk assessments that happen, and your ability to pay assessment when you're in front of a judge and arguing for a lower bail amount?
It could. I think the bail fund has probably seen that the ability of the bail fund to pay bail sometimes may change, whether a judge asks for $2,000. Currently, we're $2,000 or $2,001. I don't know.
I think Marty might have an answer.
Yeah. So I'm a public defender with the Legal Aid Society, and I am in arraignments on a regular basis. And judges are aware of these various limits, and there's always a concern that your client's bail may have been set at $1,000, but because the judge wants the client to remain in custody, will set bail at $3,000. And so that's a concern with any limit that's set, and it's something that public defenders and advocates just have to contend with. And of course, if the legislature were willing to just strip judges of that authority by mandating release in various cases, it would solve the problem. And it's unfortunate they didn't do so in this case.
So I think, having discussed bail, and now that you're talking, I think I'm going to turn over to Marty to talk about gravity knives.
Thank you.
You're
Thanks,
welcome.
Judith.
Sure.
Thanks for having me. So I am a public defender with the Legal Aid Society, and I have represented thousands of clients at Legal Aid, many of whom were charged with gravity knife possession. Oh, do you want me to?
Gravity knife. Giving this to you.
Sure. So in 2015, I represented a client by the name of Victor. Victor had an extensive criminal history, but for about a 7-year period, Victor was doing very, very well in life. He was living in Texas. He was working 3 jobs. He was living with his wife and her child. He had moved to Texas from Washington Heights in New York. And while he was in Texas, Victor got a call from his family that his sister's cancer had advanced to stage 4. So his sister had breast cancer, and it advanced to stage 4, and it had metastasized on her brain. So Victor's family said, Victor, it's time for you to come home and be with your sister. So Victor came home, he came back to Washington Heights, and he was living with his sister, taking care of her. He got a job with another family member working demolition all throughout Manhattan. And while he was on the job, he was given a folding knife, a Gerber folding knife that sells across the city, across the state, across the country. He used the knife to cut carpet off floors when they were tearing down rooms, to cut drywall. He used it for everything. And he kept it with his keys. He kept it with him all the time. It was a small folding knife that sold everywhere. He kept it with him. Victor's one big mistake was that one day in early 2015, he and another family member went to Fort Tryon Park and they were smoking marijuana. They were stopped by police. Police asked Victor to take out all of his possessions. He took out his keys, he took out his wallet, and he had his folding knife with him. A police officer then tried to take the folding knife and force it open with one hand. Police officer was able to force it open with one hand, and I'll never forget the way that Victor described it. Victor said, the police officer started trying to do all this Michael Jackson shit with the knife. And it's this strange flick of the wrist that Victor was talking about, and of course the Michael Jackson video that Victor was referencing. So Victor was arrested for gravity knife possession because he was in possession of a folding knife that a police officer claimed he was able to open with one hand. Under New York state law, up until recently, possession of a gravity knife is a misdemeanor offense, punishable by up to 1 year in jail. But if someone had a previous criminal conviction for anything at any time, let's say they had a previous criminal conviction from 30 years prior for marijuana or petty larceny, if they had that conviction and they were charged with possessing a gravity knife, a folding knife that a police officer could flick open, they faced 7 years in prison and a felony. And because Victor had previous criminal convictions, and because Victor had previous felony convictions within 10 years of his arrest, he faced a minimum of 2 to 4 years in prison and a maximum of 3.5 to 7 years in prison. So when I met Victor in arraignments, he was facing 3.5 to 7. Prosecutors were asking for bail. They got bail. I forgot whether it was $5,000 or $10,000 bail, all for possessing a folding knife that he used for work and that sold all across the city. We provided prosecutors with his sister's medical records showing that she had stage 4 cancer. We provided prosecutors with a letter from his sister's doctor showing that Victor was caring for her. We provided prosecutors with all of Victor's work history, and we provided prosecutors with proof that this folding knife that Victor was in possession of sold at Paragon Sports right in the heart of Union Square. We were willing to take a misdemeanor conviction on this. We just wanted to prevent Victor from going to state prison. Okay? Prosecutor said no. Prosecutor said no, despite all of that. There was no allegation that Victor was in possession of the knife using it unlawfully. He wasn't brandishing it, nothing. Okay? At the height of stop and frisk, 6,000 people were arrested every year in New York City for gravity knife possession, okay? Possessing folding knives that police officers claim to be able to open with the flick of a wrist. Okay? What I have on the PowerPoint here is Elliot Perilla's folding knife. February 3rd, 2011, Elliot Perilla is working in Harlem. He is tiling floors in Harlem, and he uses this Husky Home Depot knife. Elliot Perilla bought it at Home Depot in the Bronx. He's using it for work. He leaves his work site in Harlem, and he's driving home to the Bronx. Police officer pulls him over for a broken taillight, stops him, searches him, finds this Husky utility knife that he purchased at Home Depot in the Bronx. The police officer claimed he was able to force it open with one hand. Elliot Parilla had a serious criminal record, but in that moment, he was doing nothing other than coming home from work. No allegation that he was using the knife unlawfully. He's in Manhattan. The Manhattan DA's office has always been incredibly aggressive, I would say overzealous in their prosecution of gravity knives. So Elliot Parilla was charged with felony possession of a weapon. It wasn't a defense that he purchased the knife at Home Depot. It wasn't a defense that he wasn't using it unlawfully. He was convicted of a felony, and he was sentenced to 2.5 to 5 years in state prison, of which he served. So this is not what the legislature intended. Okay? The legislature passed the gravity knife ban in 1958, and it applied to an old style. Oops, why isn't this letting me?
You want to show how it works?
There we go. So it applied to this old German weapon that you will see opens by force of gravity. Let's see. Here we go. Okay.
Right.
So you can see the blade just drops out. So that's what the legislature banned in 1958. A knife where the blade just drops out by force of gravity. The law read in such a way in 1958 that also applied to any knife that could be opened by centrifugal force. And as NYPD adopts broken windows policing, numbers-based policing, they start applying the statutory language to folding knives. And so all of a sudden, what was once an easy standard, all of a sudden becomes this strange standard for criminal liability. So you can see this is a police officer at the DA's office in Manhattan, and he has a folding knife that's sold all over the city that he's trying to force open with one hand. And is there a way we can get audio here?
Should be. Oops. Oh, no, not there. The other one? The one with the. No. One more. It's got a speaker and it's.
Got it.
Okay, there you go.
My hands are sweaty. Hold on.
Are you able to flick it so that it locks in place?
So it took that officer 9 tries. It took that officer 9 tries to get that folding knife open. That knife sells on Amazon.com for $14.
Okay, go ahead.
Oh, yes.
This is like hardcore.
Sorry. That knife sells on Amazon.com for $14. My client, who is a young black man, was stopped for tinted windows. He's pulled over. This officer finds that knife in the glove compartment of his car. No allegation that he's using it unlawfully in any way. Police officer's not able to open it the first time that he tries. My client came back to court 14 times before his case was resolved with an ACD and 2 days of community service for a knife that sells on Amazon. That was the standard for years, and that was NYPD policy and prosecutors' policy for years. Height of stop and frisk, 6,000 people arrested every year. In 2018, 3,500 people arrested for gravity knife possession. 85% of those people, black or Latino, 96% men. What my colleagues and I were able to demonstrate with a lot of data analysis was that, like so many laws in New York City, this law was just used as a massive net. You just cast the net wide, draw people in. NYPD takes this law, casts the net wide, draws thousands of people in, and then prosecutors decide who's a good guy, who's a bad guy, who gets the ACD, who goes to prison. And for those people who have previous criminal convictions, who are trying to re-enter, who are trying to live decent lives, working construction jobs, working day laborer jobs, prosecutors often didn't hear it. They didn't hear family members dying of cancer. They didn't hear client is working. They just didn't hear it, and they were trying to send people back to state prison. What we thought was there were many things that were offensive about the law. In fact, this is a knife. This is a carabiner keychain. It was purchased at a hardware store in Manhattan. Our client, Jesus Rodriguez, was sentenced to 2 to 4 years in state prison for possessing this carabiner keychain. He spent 2 years in prison. His conviction was ultimately reversed on speedy trial grounds. But it was an outrageous law. And what was most outrageous is that the knives sold everywhere. Okay? The knives all across the city. This law never had anything to do with public safety. It never had anything to do with the presence of knives in New York City, because NYPD never, not once, arrested a retailer for selling the knives that our clients were possessing. Okay? We told the legislature about this. We told the governor's office about this. We told every court that we could about how prevalent these knives were throughout the city. I asked interns and investigators to try to find locations in Manhattan where these knives were sold. And in a 2-day period, they found 130 stores. Okay? 130 stores. While thousands of black and brown men were being arrested. This gravity knife law was never about knives. It was just about police and prosecutorial control over our clients. So,
Does this law exist anywhere else in the country?
nowhere else in the country. Nowhere else in the country. There are bans on gravity knives in various parts of the country, but those bans apply to the 1958 knife that dropped out of the handle by force of gravity. Things got so bad that in 2010, DA Vance entered into deferred prosecution agreements with retailers in Manhattan, where he said to the retailers, pay us $2.8 million and we won't prosecute you for selling these knives. Well, just wait. So they said, well, we're not selling illegal knives, we're selling folding knives. What are you talking about? He said, well, I have DAs and interns who have taken your knives and they've forced them open with one hand. So you're selling illegal knives. They said, all right, we'll pay $2.8 million so we won't get prosecuted. No one was ever arrested. And as we showed, the knives remain ubiquitous throughout the city. What was so outrageous that wasn't reported in 2010 is that DA Vance's office carved out an exemption for Paragon Sports and Union Square to sell high-end, expensive gravity knives, okay, on the unfounded rationale that expensive gravity knives aren't used to harm people. Okay. So, and tell me if I... Okay.
Yeah, you got about 5 more minutes.
Okay.
Yeah.
So one of the DAs responsible for this agreement was deposed in a federal lawsuit. He's asked, at the end of this paragraph, there's a statement, however, this agreement exempts Paragon sale of custom knives defined as individual, one-of-a-kind, handcrafted knives, separately marketed and sold to collectors. Answer, I see that. Question, and why was this provision included? Answer, it was a negotiated provision in order to reach an agreement. Paragon, uniquely based on our investigation, or almost uniquely, had an inventory and displayed as merchandise very high-end kind of one-of-a-kind knives for collectors, real high-end stuff. And it was negotiated that the agreement would not, that those knives, if they did constitute a prohibited knife, would be excluded from the agreement, both as an incentive to enter into the agreement, but also to reflect that we were just not seeing $1,000 or $2,000 or $5,000 knives being plunged into people's temples and cutting people up. So the risk comparatively of those knives was less than other knives. So that is the state of law enforcement for years. For years. NYPD doesn't arrest the retailers. DA Vance gives one retailer authority to sell expensive knives. So 6 months ago, if you walked into Paragon Sports, you would see on display, if you go to their website, you'll see advertised expensive gravity knives. You would also walk into the store and see for sale, in violation of the law and in violation of these agreements, inexpensive gravity knives. And you would see those knives at stores throughout the city. So this is a major, major problem. And my colleagues and I tried, along with so many advocacy groups, including incredible support from Vocal and many other groups. We pressed many different challenges in federal court and in state court, and we lost a lot. We lost a lot in courts. Legal Aid actually teamed up with Second Amendment groups to challenge the law, which was a strange political team, to say the least. But it became an incredibly effective political team. It became an effective legal team and an effective political team. As I've said, for me, this was never about knives, but our work with advocacy groups across the spectrum, after years, finally came to fruition this year. The legislature and Senate passed changes to the definition of a gravity knife in 2016. Governor Cuomo, in response to pressure from NYPD and DA Vance, vetoed that legislation. 2017, the Assembly and Senate passed another bill changing the definition of a gravity knife. That passed 136-1 in the Assembly, 61-1 in the Senate. Governor Cuomo, facing pressure from NYPD and the DA's offices, vetoed again. But because of advocacy groups throughout the state, because of a much more progressive legislature, in 2019, the governor finally signed. And this legislation was the most ambitious yet, because it just strikes gravity knife from Penal Law Section 265.01. So it just takes gravity knife out of the penal law, okay? And it has stripped prosecutors. Thanks to the advocacy group. Governor Cuomo signed this year. It has stripped prosecutors of the authority to have control over our clients, and it has almost entirely stripped the police of this authority to stop our clients for possessing knives that sell across the city. What NYPD said the day after Governor Cuomo signed the repeal is that NYPD retains authority under the MTA rules to arrest people for possessing these knives on the subway. And that is true, but the penalties are much less significant. It's not a crime, it's an infraction, punishable by up to 15 days in jail and a small fine. Needless to say, the repeal of the ban is an extraordinary victory for thousands of our clients. Really, the next front is for lawyers and advocates to push retroactivity as aggressively as possible. DAs have been dismissing open cases. DAs have been dismissing any open ACDs. And now the fight is in cases where clients have been convicted, but their cases are pending on appeal. And for those clients who've been convicted and they've exhausted their appeals, my appellate colleagues are still trying to seek relief for those clients, and that really is the next fight in this case. So,
Thank you.
Thank you.
Yeah.
Thank you. Victor was in front of an incredibly law and order judge, and we made a motion to dismiss in the interest of justice. And the facts were so outrageous in Victor's case that this judge agreed that if Victor stayed out of trouble for 1 year, she would dismiss. So she dismissed his case.
Regarding restitution. So, in the case of this, as well as in the case of marijuana, this is now repealed. So the people who served time in previous years for this, I know that some people say when it's the law, it is the law, and if you broke the law, you broke the law. But when the law has been changed or removed, and the spirit of the law indicated that perhaps it wasn't even a good law, is there any possibility or for anything to be done for the people who served time and have this on their record and everything?
And that is absolutely the next fight to be had. And so when the governor signed this year's repeal, he said in his signing statement that his signature really was necessary to address a constitutional infirmity in the law. So he's saying that the law was unconstitutional. And I think that appellate advocates should use that language to argue that previous convictions were unconstitutionally obtained. So that's one angle. There are other pending challenges, and one challenge that I think is compelling and that recently developed traction in the Southern District Federal Court is that this wrist flick test renders the gravity knife law void for vagueness, meaning a normal person can't know whether their folding knife is legal or illegal if criminal liability turns on someone else's athletic skill. Like if you can go to jail because a police officer is good at flicking the knife, that is not a constitutional standard that we should tolerate. And hopefully that argument wins the day.
If it wins, what can happen for the people who've been already?
We would hope that their convictions would be vacated. That's what we would hope for.
We can actually speak to that, and maybe that's a segue to talking about marijuana.
Sure. Yes.
Thank you. It's a segue because you had a question about marijuana. And so, as people have seen, we did not get legalization this year. It was a tough fight. From time to time, we thought we were going to get legalization, and probably almost everybody in this room had something to do with that fight. It was a very broad-based effort. And we were hoping very much that the Marijuana Regulation and Taxation Act was going to pass. It would have done a lot of different things. We did not get that in the end. We got decriminalization. I'm going to ask Samantha to talk
about statutory expungement law. So as part of marijuana decriminalization, the bill includes the expungement of past convictions for marijuana possession for those sections of the penal law that are now going to be decriminalized going forward. And this is a big deal because New York State has never had statutory expungement. So in certain cases in family court, the court has been able to expunge records, but there hasn't been an expungement law that automatically expunges criminal convictions. Exactly. So in New York State currently, if your case results in a dismissal or a violation, which is considered a non-criminal conviction, your record is automatically cleared. It's automatically sealed, but those sealing provisions are actually pretty robust and do a lot to really clear the record. Certain records are destroyed, other records are made inaccessible. In New York State, before this bill passed, if you wanted to seal a criminal conviction, you were only able to apply for sealing under a relatively new sealing law that went into effect in the fall of 2017 that's super, super limited in its relief and also super limited in terms of who is eligible for relief. And, research has shown that if it's an application-based process for clearing your record, the number of people who benefit from records clearance is a fraction of the number of people who are eligible. So, for example, under this past sealing law where it's application-based, there were reports put out that approximately 600,000 people were expected to be eligible to seal their records. In about 19 months, 1,100 people have sealed their record. So what's big about this decriminalization bill, despite feeling the loss of having not gotten legalization, is that it automatically expunges the records of people with certain marijuana possession convictions, and it also expunges records for people who are convicted of marijuana possession for certain parts of the penal law going forward. And going back. So it has both retroactive expungement forever. So the two, I think what might be helpful is to talk about sort of what marijuana under these two sections of the penal law looks like going forward. So what this law does, unless Judy, if you want to.
No, go ahead.
Okay. So
Please.
Basically, going forward, marijuana possession under 2 ounces is going to be a violation only, which means that you can get a conviction for marijuana possession under 2 ounces, but it will not be a criminal conviction. It'll be a violation, which is considered non-criminal. So previously, if you possessed less than 1 ounce of marijuana, it was a violation, but you had to pay $100. That was the penalty. Now you'll have to pay no more than $50. The other section of the penal law that this bill amends is Penal Law 22110, which was for possession between 1 and 2 ounces of marijuana. Previously, if you were convicted of that, it was a Class B misdemeanor. So you would get a criminal conviction for that. Now it will also be a violation, and you'll have to pay no more than $200 for between 1 and 2 ounces. So possession of marijuana, I know. So there's possession of marijuana under 1 ounce. There will be a maximum fine of $50.
Under 2 ounces.
Marijuana possession between 1 and 2 ounces will be a maximum fine of $200.
So it's more for less.
No, it's more for more. Less than one or less, 50. 1 to 2, 200.
200.
Yeah.
And what's going to happen is that basically these 2 sections of the penal law covered up to previously 25 grams of marijuana. I think 2 ounces is like 28.36 grams of marijuana. It's I don't know where the 25 grams came from in the first place. But so what's going to happen under the expungement provisions of this decriminalization bill is that all convictions for possession of under 25 grams of marijuana will be automatically expunged without individuals having to do anything. And going forward, anyone who is convicted of possessing under 2 ounces of marijuana will only receive a violation conviction, and those violation convictions will be automatically expunged without anyone having to do anything.
At the completion of sentence,
we think. So the bill is unclear on when the expungement will take place going forward, but we think that it is likely at the completion of sentence, so once the fine has been paid. So again, this bill does not look like many advocates hoped it would look, but the introduction of automatic expungement of criminal convictions is significant in New York State, and we hope will sort of be the first of a broader expungement law that will benefit more people and more types of convictions.
And I'll just add in, CSS has had going our expungement campaign that Avery has been heading for a bit of time now. When we first started, it seemed like, people were calling us kind of crazy, like, you will never get expungement in New York State. What are you talking about? Maybe you should try for sealing. This law now has the term expungement defined in it. Some of us helped in drafting that language. It's kind of cool to see what you wrote as a law. It's there now. The term expungement exists and it's defined, and now it's effective, or it will be, a certain number of days after the law has been signed by the governor, which it hasn't been yet, but we think it will be very soon. So that's critical. It's as Sam said, it's the start. We think, we'll get the systems together. We'll figure out how the court administration is going to do it, how Division of Criminal Justice Services is going to get their systems together to do this and make it really work. And then we're going to try to get it for other things, such as, I mean, the obvious next candidate would be, what about all of those hundreds of thousands of convictions for gravity knives for something that the governor himself has said was an unconstitutional law? Shouldn't all of those be automatically expunged? Yeah, they should. So maybe that's, step number 2. We see this as a really excellent way to start. Again, we're not thrilled with what happened in terms of legalization and decriminalization. It's not what anyone had hoped for. But one other additional thing that I want to mention is that we were very careful as we were drafting this to do whatever we could to make sure that we are not going to be putting people in immigration proceedings in some kind of trouble. If we had just left it as, everything gets automatically expunged, that could have caused people who are in immigration proceedings to have problems. What we needed to do was, and we consulted with immigration advocates. I'm not one, and it's very complicated stuff, but there's a provision in there that allows people to apply to get even deeper relief if they need it for immigration purposes. So that's also a win.
How many people does this affect?
I think they're estimating, I've seen around 600,000 arrests, I think, will be.
This is going to be much more than 600,000.
Well, going back, possibly.
I think it's going to be more than 600,000. We don't know, but we'll find out soon enough. Yeah.
So it already took effect.
No.
So it has not yet been signed by the governor. And once it is signed by the governor, it will go into effect 30 days after that point.
However,
the one thing is that expungement of past convictions is going to take quite a bit of work on agencies' parts to figure out what processes they need to set up in order to effect expungement. So agencies will have 1 year to expunge past convictions once this law is signed by the governor and goes into effect. However, during the course of that year and beyond that year, they are those agencies, so the Division of Criminal Justice Services and the Office of Court Administration, cannot report on those convictions for background check purposes. So if someone orders a background check and they have a conviction for 22105 or 22110, it should not appear on the background check in the interim.
And that's even if you're 50, 60 years old?
Yeah.
Yeah.
Maybe especially if you're 50, 60 years old. I can relate to that.
What do these changes mean to the movement going forward, like moving for legalization? Does it sort of put that some sort of halt, or are things still rolling for next year?
Do you want to talk to that, Nick, at all?
I mean, I can very generally say no, like we still want legalization. So I don't know exactly how this bill was framed when they were passing it, but I think the intention is definitely to go back in January and try and pass legalization.
Yeah. Avery.
Yeah, I would say follow Smart Start, the Coalition Drug Policy Alliance has done this work for a very long time. Around legalization, and reasons why decriminalization isn't the best is because black and brown folks are still going to get criminalized, right? So we got to get legalization inside next session so our folks aren't getting harmed by the system.
But do you live in our communities with people talk about legalization? People talk about legalization, and you make some very good points, but you don't live in the communities. Come to my house at 7:45 and walk to my front door, and there's a whole bunch of young adults congregating right in that little enclave doing their thing. So that's an invasion of me. When I used to smoke, we went to the big park. Not in the neighborhood.
Let me tell you how to do it.
Yeah, but we didn't disrespect other. We didn't disrespect our parents or the people in the neighborhood that would tell our parents after they did what they had to do to us. Then you have these no-smoking buildings that are coming up. I smoke cigarettes. So you mean to tell me I can't smoke a cigarette in your building, but I can light up a joint?
No. I don't mean to say that, because they have also changed the public health law to say that smoking includes marijuana. So I'm not saying that answers your questions, but I'm,
on that issue because
yeah.
It's not about it's the behavior that comes behind the smoke. I gave you smoke, do your thing, but it's the behavior that comes behind the smoking. And people that want to legalize this don't live in my neighborhood. They from Colorado and California, where they want to make money to come to in New York. You got to be real with that. You got to. And then a lot of people who are not black and brown, if you want to call it like that, is smoking, and they don't want to have the risk of getting arrested. Be that 1 in 100 million getting arrested. So, you know, you got to look at all variables on this. So that's another conversation, but I'm going to fight y'all.
It's a lot of different voices. The woman in the white shirt in the back.
I think that the association with the activity and the behavior itself is the criminalization. Like, not everyone who smokes marijuana is a person who's committing trouble in neighborhoods or anything like that. But the interruption of space by smoking itself, you could argue the same thing for cigarettes. Like, you're disrupting my space by smoking a cigarette in my building the same way the kids are disrupting your space by smoking marijuana in your building. I think that it just speaks to more of the general criminalization the media has done around people who smoke marijuana, and rather than people themselves in the communities, because I live in like one of the harshest parts of the Bronx, but all of the people I know that smoke weed, they're some of the nicest people I've ever met in my life.
They're mellow.
But I'm not attacking nobody's personality, and I'm not saying the behavior is criminal, and I'm not saying none of that. When I was a weed smoker, many a time. and I'm the beautiful person God ever created. I'm just saying, we'll talk later on.
That's right.
Okay.
Gentleman in the back with the yellow shirt. Yes.
How's everybody doing? I'm John with Baltimore, New York. Making my I think that the onus has been put on black and brown people who smoke marijuana, say on the street corner, than it is for white folks or non-black or brown people who smoke marijuana on the corner. I think the impetus is that we're troublemakers, or something is untoward is going to happen in an hour or half an hour from the time they see it. And that's a bad mistake to make, because a lot of black and brown kids are in school or in college, and it's a stigma that comes with seeing a group of them smoke, and it's wrong. You know, and some of the comments in this room are moving towards that kind of stigma, and I think it's wrong. A black and brown person should not have a record because they're standing smoking on the corner a joint. And I think it's wrong for people to assume that they're going to be causing trouble because they're doing that kind of conduct.
I think what I'm hearing is the building of a need for a much larger conversation about this than we can conveniently have in this room, in the space that we have. And I'm not trying to minimize it. I think I'm trying to maximize it and say, let's set up another time when we can talk about this, because everybody's voices need to be heard in this. And I know advocates are trying very hard to make sure that everybody's voices are heard. But let's see if we can set something up about that. So I guess what I'm going to say is, we don't have a whole lot of time left. If people have actual questions that might be addressed to the panelists, yeah, go ahead.
So for anybody who possesses, and I guess who gets caught in possession of 2 ounces before marijuana, what is the court like for them?
The question is, if you're caught with possessing more than 2 ounces, that I think could be a misdemeanor. It could be a criminal conviction. It's not clear what would happen to you in court. There might be an offer made to plead to something less than that. A violation level offense now. You might not end up with a criminal conviction behind it. You might even get an adjournment and contemplation of dismissal. But that above 2 ounces is a misdemeanor. Large amounts could be a felony. Question over there.
Judy, this might be a question about the definition of expungement, which you mentioned.
Mm-hmm.
I know with the ceiling law that was passed, it dealt with the conviction, but it still allowed for fingerprints and booking photos to be retained by certain agencies. I just wonder if with expungement, if it not only deals with eliminating the conviction, but also all of the paperwork associated with that, or if that's been resolved yet, or if we're still waiting to hear, for example, fingerprints or booking photos?
Good question. The existing sealing laws that we've had, forever and ever, for cases that are terminated in someone's favor, CPL 16050, have always said that your mugshots and your fingerprints are supposed to be returned or destroyed if you don't have another record. That's been followed, in the breach by the NYPD in particular, and by prosecutors' offices as well. The new law, the expungement of marijuana convictions law, does speak to destruction of records, and I can ask Sam to tell us more about it.
Yeah, so our understanding of what we think will happen to convictions that are being expunged are certain things will be destroyed, fingerprints and mugshots associated with the arrest. Other things will be sealed and made inaccessible to the public, so like the remaining court records, and they will be marked expunged. So either at the top of the digital file, or if it's a paper record, it will actually be marked in some form that it's been expunged, and it will not be accessible to anyone except the person or their agent. There is also a provision in this bill that allows individuals to request the destruction of those remaining records that are marked expunged and sealed, but that is not automatic.
Right. And we're not exactly sure how that's going to work. I don't think anyone is. Yes, question.
Anything on the agenda for reentry in particular?
Excuse me?
Any more issues or topics for the agenda coming up for reentry? People from the penal system?
There are plenty of things on our agenda. The question is, next year, what are we working on? Plenty of things. I mean, I guess my particular interest and emphasis is on expungement. So I'm interested in trying to, get as many things expunged as possible and broaden our laws. There are lots of sort of criminal justice, the intersection of criminal justice and reentry related things that are going to be on people's agendas. Certainly, legalization is on people's agendas of marijuana. Other, sort of enhancements to criminal record destruction and things that would allow people to more clearly be able to move forward are on the agenda, such as a statewide effort to get legislation that would ban the box. We have a law in New York City called the Fair Chance Act that says that most employers in New York City cannot ask on the initial application whether you've ever been convicted of a crime, cannot run a background check either, until there's a conditional job offer made, at which point they're allowed to, with certain very heavy restrictions. This law has been helpful on some level because it's helped people have a face-to-face conversation about their fitness for a job, as opposed to being, kicked to the side because they have a record right from the start. It's not a solution. We think expungement is still very, very needed, but it's been a good law because it has allowed people to have those conversations. More people are getting jobs, and it's been quite helpful. So there have been efforts to expand that to the state level. There are also efforts to get protections for people in housing. Everything we've been talking about is, sort of employment-related, licensing-related. Expungement obviously would be very helpful in going forward for private landlords who run background checks and at this point can deny you if you have anything on your record. There's no law that says a private landlord has to do anything in terms of a background check and follow any certain procedures. They can do a background check on me tomorrow and deny me an apartment, and nobody can do anything to them. There are attempts to try to get protections in the housing sphere for people with past convictions who are continually being denied a place to live. I guess those are just a few of the things that come to mind. There's a lot of other things. But, yeah, you're welcome. Question?
I have a question. I had a situation, one of my students. I work with youth 18 to 24, that's criminal justice involvement. So one of the young ladies came to see me the other day, and she has a violent crime, I think it's a misdemeanor. But anyway, she also has a certificate of relief.
Mm-hmm.
Would that preclude her from getting a license for a home health aide?
Question's been raised about what's the effectiveness of a certificate of relief from disabilities if somebody has a past conviction for maybe violent behavior and they're now applying for a license. A certificate of relief from disabilities in most cases for most kinds of licenses is helpful. It's a state it creates a state presumption of rehabilitation, meaning that it basically says the state has said that I'm somebody who's moved on, I've made strides, I've made changes in my life. It's something that the law requires the licensing agency to consider. There are certain circumstances, they're somewhat limited, where you need to have a certificate in order to get a license. Security guards, for example. If you have certain kinds of felonies, you can go to their security guard school, you can pay them money, you can go to take your test for the state of New York and give them $300, and they will turn around and send you a letter saying, sorry, you're not even eligible to apply, we're keeping your money. A certificate will require them to consider you on your merits. A third one is paratransit drivers. A lot of guys go out wanting to be paratransit drivers, including someone who I represented who got the job, got in the car, went out to drive, immediately was arrested for driving without a special kind of license. No one told him he had to have it, and it was kind of a bear getting it because he needed to get a special certificate that said that he had the ability, that the court had considered his fitness to drive a school bus with school children. It's this very weird language. But so paratransit drivers also may be facing some barriers that a certificate could lift. It does not expunge a record. It doesn't seal a record. It doesn't mean that anything is less available for public view. But it's all we've had until now to try to help people as a tool. So it's helpful, but it doesn't do everything. So,
Judy?
Yeah.
Hi. So we work with candidates once they've been released from incarceration, and generally candidates that have a criminal conviction record, period. We help them with the kinds of resources and understanding they need to be more marketable in the labor market and connect to employment. One of the things we do when we do that is we educate them on the issues of the Fair Chance Act and tell them how it applies to them and what their rights are based on that act. But one of the things that we've struggled with, we're closely with New York City Commission on Human Rights, but we struggled with how do we address the issue about those employers here in New York City who are still getting around that reality. And as you know, most employers' job applications are electronic. So now it's where you're filling out the electronic application, if that question is there that asks about conviction, history, or past felony, or whatever, you can't even go forward.
Right.
Decide not
Puts
to
you out of the
answer that
system.
question.
Yep.
Right. So you're forced to answer that question, which in effect violates the Fair Chance Act.
Right.
So we don't tell our clients not to answer the question because they won't apply for the job. But at the same time, it's the whole idea behind the Fair Chance Act has been now negated because the employer knows before they get into the interview that I have a record, right? So what can we do in working with your organization, advocacy organizations, we work with the Commission on Human Rights, the Legal Aid Society, I mean the Legal Action Center. We're trying to figure out what can we do to sort of curtail this activity by employers.
It's happening all over the place. I didn't mean to say that the Fair Chance Act solved any problems.
No,
It's helped, but people are violating it, 6 ways to Sunday. And what I would say in terms of that, that's a violation. An employer putting that on their website, that's a violation. Even if their headquarters is in, Akron, Ohio, if they're doing work here in the city and hiring people in the city, having those questions on their application is a violation of the law. So you've been trying to address that. We suggest, letting the Human Rights Commission know in some circumstances they've managed to shut people down and stop that. If you're seeing it a lot and it's not changing, you say you've been in touch with the Legal Action Center. I think that's a good idea, getting in touch with us. Other advocates that are working in this area, we might bring a lawsuit. We might bring a lawsuit against them for violating the Fair Chance Act. We've done that in the past. We can bring lawsuits against employers who are violating that law. Part and parcel of that, they often also are violating laws having to do with background checks. When that happens, that sometimes bumps it up so that we're actually in federal court, and it becomes a lot more important. So we would be happy to talk to you, and I know Sam would be as well. If you're seeing patterns, and particularly if it's a big employer, we'd be interested in talking. So, thank you. And Carlos had a question back. Oh, you were pointing to him. Okay, sorry. Question in the back.
Counsel Services, basic it's a
So my question is, in terms of this, when I first walked in, there were references to different statutes, different laws. So I'm wondering, like, once the laws are enacted, it usually goes into what's called sessions law, right? And you can see the laws as it's written. So I'm wondering, so my question is basically, is it a package of laws? Like, is there certain sections? For example, many years ago, when the TAC was the governor, in 1995, they had the Sentencing Reform Act. So I'm wondering if there's a package of laws, but I want to find the laws. So, or is it scattered throughout the procedure law and other ones?
I think the latter. We weren't able to say, like, this was the, Reentry Reform Act of 2019. So you won't be finding them in a package like that, unfortunately. So I think we're both out of questions and out of time. I want to thank our panelists for being with us and answering good questions. And thank everybody for coming. I think this is really good, and you can, bring to those who weren't able to come information that you got here. So thank you for joining us today.